Hello everyone, I am Sir, am I audible to you?
Yes, clearly.
Sir, shall we start?
It's 5:58. I suggest we wait 2 minutes more and start at the time of 6.
Yeah.
In the meanwhile, can you hear me and see me clearly?
Yes.
Yeah. Audio video feed is fine?
Yes.
Excellent. Let's wait for 2 more minutes.
Shall we start?
Yes, go ahead.
Hello everyone, welcome to today's webinar. I'm 𝗱𝗃𝗁𝗶𝗃. Hope you all are safe. Today's topic of discussion would be virtual advocacy in arbitration. And we've been joined by the guest of today's webinar, Mr. Garv Malhotra. Mr. Garv Malhotra is a commercial lawyer specializing in international disputes and is currently the partner of Skywards Law. He leads the firm's international dispute and arbitration practice. He has acted for his clients for courts and arbitration tribunals in matters involving laws of India, Singapore, and England. And under ICC, SIAC, LCIA, and unilateral rules, he is also a certified mediator and a cross-culture negotiator. Thank you so much, sir, for joining us today for this webinar. You may start.
Hi, everyone, and welcome to this session on virtual advocacy in arbitration. I hope you're all doing fine and that the coming days bring you a lot of health and happiness. Advocacy is the art of persuasion. Virtual advocacy is the art of persuading someone virtually. Right now, that means through audio or video conference like Zoom, WebEx, etc. So in today's short session, aimed at lawyers and law students, we will look at virtual advocacy with a focus on arbitration. Now, allow me to give you a little bit of background about this session. When the pandemic started, like many lawyers, I was apprehensive about conducting full-fledged hearings virtually. I was used to doing hearings physically and felt that that was the most efficient way to conduct hearings. Now, even prior to the pandemic, I, like many lawyers, had done procedural hearings virtually. In fact, in the year 2018, I had done an emergency arbitration under the rules of the Singapore International Arbitration Center, where the full hearing, which lasted a day, was conducted by a simple phone call or an international dial-in audio conference. But conducting hearings, merits hearings, virtually was a different ballgame altogether. Conducting cross-examination of witnesses was something completely different. However, now with over a year's experience in conducting hearings and trials in various formats during the pandemic, including virtual, physical, as well as hybrid, I believe that virtual hearings are here to stay and that they're much better than no hearings. I still prefer physical hearings and believe that there are some cases which actually require physical hearings. But like many of us last year, I have spent innumerable hours arguing, examining, and speaking while looking at the camera. And this has certainly changed my outlook. Also, being a tech enthusiast, I have constantly experimented with a number of new gadgets as well as screens. Hang on. Allow me a second. One of the problems of virtual hearings are technical difficulties, which is something we, unfortunately, despite our best efforts, always face. I am facing some issues with my notes. Yeah, we're back. And so, yeah, I was talking about how I've had the chance of experimenting with a large number of gadgets and screens over the last year. And when LawSikho invited me to do this webinar, I thought of taking this opportunity to make the case for virtual hearings as a default mechanism in arbitration and as the default alternative to adjournments. A lot of what I say also applies to courtroom litigation and perhaps many other areas. But the inherent procedural flexibility of arbitration as a mechanism for resolution of commercial disputes enables the arbitrators and the parties to drive the procedure themselves without being governed by court rules, circulars, and practices. And with this background, this session is going to be divided into 5 parts. To start with, I will make a case for virtual hearings and discuss why we should get more comfortable with virtual hearings. Thereafter, we will talk about the required setup, hardware, software, as well as provide a working checklist for conducting virtual hearings efficiently. Thereafter, we will talk about the virtual hearing document or the logistics protocol, the document which talks about how the hearing is to be conducted, as well as the steps that have to be taken. We will then move on to examining hearing tips in relation to arguments, as well as examination of witnesses. So without further ado, let me give you a small caveat. I am not an expert on the ever-evolving topic of conducting virtual hearings. In fact, just a couple of years ago, I barely had any idea what Zoom was, and still use the word Skype as a verb. And perhaps one day I will look back on this video and laugh at the rudimentary nature of the technology that we are using right now. But like many professions in the pandemic era, we are adapting to situations in which we have limited prior experience and have picked up a lot of valuable lessons in a very short period of time. So without further ado, let me jump and start making a case for virtual hearings and give you my reasons why I have started to get much more inclined towards the advantages of virtual hearings. And I will go through each of them one by one, which are there in front of you. Let's start with the first one. The basis of a hearing in an arbitration is not a physical day in court. It is simply an opportunity to present one's case. And with today's audio and video technology, ideas, positions, and can be efficiently conveyed over large distances. Arguments can be efficiently made irrespective of where people are sitting. And this is happening without statements being so-called lost in translation. If you think about it, in some ways, it's almost as if I'm sitting right in front of you and having this conversation with you. And think about this a little more. This is the first time in our 2 million year human history that we can communicate so efficiently over such large distances. By contrast to this, in March 2021, right before the second wave of the pandemic hit India, I had the privilege of appearing before the Honorable High Court of Delhi. This was in an arbitration appeal under Section 37 of the Arbitration Act. I was led by Mr. 𝗍𝗃𝗃𝗹 the day before he became designated as a senior advocate. And this was in that short spell where the Delhi High Court had suddenly opened up for hearings in a physical format. And I was looking forward to the experience. And when we went there, this is how the court looked. Can I just confirm, Subhasmita, can you see what I'm sharing on my screen?
Yes, sir.
Excellent. So this is how the courtroom actually looked. We were standing on one end, and there were 2 layers of fiberglass, as well as about a few layers of masks between us and the judge, and a 15 feet distance. Counting all the layers that were between us, there were about 4 or 5 of them, and the judge, his staff, and we were communicating amongst ourselves the best we could through the help of microphones and speakers, as well as trying our best to make eye contact while making submissions. While the hearing went well, we came out happy, but the detachment of the experience further inclined me towards the advantages of virtual hearings, because I came out thinking that perhaps the hearing would have gone the same if we had done it virtually, and perhaps I would have actually preferred to see the expressions of the judge when we were making the submissions. And therefore, I also realized that what we were actually missing was the charm of going to court, as well as the social interactions and the opportunities that came with it. In sharp contrast to this experience was the experience of cross-examining witnesses on a large screen in an international arbitration we did last year under the ICC rules, where we had access to excellent technology and opportunity to work with good transcription teams, stable online dispute resolution services providers, and with the help of new age technology and big screens, we were able to have larger than life images of the witness while we were cross-examining them. So much so that every flicker of the eye and every bead of sweat falling down the face was clearly visible as well as magnified. Think about it. For the first time, we are also able to do such a thing whereby when arguing, we can see the tribunal, the witnesses, the transcription, as well as our own notes and documents in the same 180-degree field view. All you need to do is add a couple of more screens. Moreover, with the ability to focus the witness and the tribunal's attention on a specific part of the document, and the ability to confront a witness by casting a document on the screen and looking at their magnified expression, works like a charm if you can get it right. As such, in today's reality check pandemic world, given the social distance and mask protocols, I believe that virtual hearings are the best bad option forward. They are often just as efficient as physical hearings, if not more. And at least during the pandemic era, they often end up being a more personal advocacy experience. Virtual hearings also allowed justice to be dispensed and disputes to be resolved, businesses to move on who are waiting for finality for business disputes. Now, I've spent substantial time explaining the first reason. So let me go quickly over the other three reasons. My second reason for getting more inclined towards virtual hearings is that there is a substantial reduction in costs. Arbitration came on the scene about 100 years ago as a cheaper and more efficient alternative to resolving disputes as opposed to courtroom litigation. However, costs have become a very major issue in arbitration, and there are many examples of this situation. For instance, the $62 million legal costs award, or a 450 crore plus legal cost award to our late Professor 𝗍𝗯𝗶𝘁𝗂𝗹 in UCO and his team in UCOs versus Russia, to many others. Now, in addition to lawyers and arbitrators' fees, a large amount of money in any arbitration is spent on flying everybody to the same city, hosting them up in hotels, renting hearing venues, as well as printing and shipping documents to arbitrators in different parts of the world. Full disclosure, I have been the beneficiary of traveling and staying fancy for work, and I have enjoyed that at the relevant times. But at the same time, I've had moments in my career when I've looked at cost submissions during the cost submission stage at the end of an arbitration, and just felt appalled at the amount of bills that end up just mounting by the end of an arbitration. When we compare virtual hearings to physical hearings, they end up being substantially lesser in cost. And that's simply because hosting a hearing or like a webinar on Zoom is much more cost efficient than renting a venue and getting everybody and ordering refreshments and making sure all the logistics of that are working out fine. Sometimes we end up doing arbitration in a hybrid format. That means some people are appearing by video and some people are appearing in person in a physical hearing. My experience so far has been that hybrid hearings end up costing much more than either physical or virtual hearings. And that's simply because you have to do twice the effort, do everything 2 times over. You have to have double infrastructure, which in arbitration, unlike in court, we rent on a pay-per-use basis. So you end up paying both the hearing venue as well as the online dispute resolution service provider. So in summary, wholly virtual hearings and trials end up clearly costing much less than doing this party in person. The client does not have to pay for business class flights and 5-star hotels and venue costs, and documents don't have to be couriered to people all across the world. The third reason why I have started getting more inclined is that virtual hearings reduce the stress on the system. Pendency of disputes is a macro issue that is plaguing a lot of developing countries. And you realize that pandemic is just increasing that problem. The National Judicial Data Grid shows that we have substantially increased the pendency of our disputes before the courts in the 2019 to 2020 period, and we're still going to have to wait to see how it comes out in 2021. But clearly there is a lot of pendency, and these and just adjourning hearings is just clogging up the system even more. Virtual hearings also ensures that short hearings can happen quickly. Instead of handling everything together, you can have short hearings which can be scheduled much easily because of the lack of logistics involved in flying everybody to the same place and hosting everybody. It's just easier. And the last reason is our carbon footprint. Let's face it, we lawyers have a very high carbon footprint. I can't speak for everybody, but personally, I know I have burned through a lot of tanks of petrol just like shuttling from one court to another in Delhi. And even in, for instance, in 2019, I spent about a month sleeping on a plane, doing 15 overnight round trips between Singapore and India, shuttling back and forth. There is a lot of travel which is involved in an arbitration counsel's life. It has always been a part of our work. And despite the fact that we may enjoy some parts of it and not others, but there is no denying that there was a substantial carbon footprint that comes with it. And we also, as lawyers, rely heavily on printed materials, books, and various other things, which is something that we can reduce when you're doing virtual hearings. Instead of printing multiple sets of the same documents, if your hearing is on the screen and when you have to cast the documents on screen, you start getting more used to just using documents in soft copy. And therefore, in summary, I think virtual hearings are here to stay. We should embrace them and learn to ace them. I still like physical hearings and believe that there are advantages of a physical hearing which are hard, if not impossible, to replicate when it comes to virtual hearings. But at the same time, I do prefer virtual hearings over no hearings, especially knowing after 1 year's experience that a lot of cases actually require hearings and they're just being postponed in the physical versus virtual debate. Also, once the pandemic is over, based on our technical capability and our knowledge at that point of time, we can conduct a fresh cost-benefit analysis and see whether we want to stick to virtual, we want to go back to physical, or in what manner we want to do it. Some procedural hearings virtual and cross-examination physical. Again, that's a call that will have to be taken once the pandemic is over and in light of the prevailing technological conditions. Let's face it, a couple of years ago, none of us knew what Zoom is. So it's an ever-evolving field. So with the first part of what I wanted to talk to you about done, let's talk about the second part. In the second part, I want to discuss with you a checklist. A checklist for what you need to conduct a virtual hearing. Now, if you ask me, what is the ideal setup for conducting a virtual hearing? What is the ideal setup on how to ace a virtual hearing efficiently? My answer will be to each their own. Everybody has their own style of advocacy, and that goes same for the kind of setup that you require to do a virtual hearing efficiently. Last year, when I had a chance to be a part of my first ever fully virtual arbitration trial. I was grappling to find resources to assist me on what to use. In fact, I was even very confused about how many screens I should be using. And we created an internal checklist and an internal bunch of resources, which was for our own use, which I'm happy to share with you. But at the same time, understand that this is an evolving checklist. It like a couple of months ago, the checklist was much smaller. And a couple of months later, this checklist will certainly have a few more entries. And I hope you see them just as mere suggestions rather than prescriptions of what you need to conduct a virtual hearing efficiently. I am right now in this assuming a complex virtual hearing with all the bells and whistles, including your live transcription, as well as multiple parties and multiple arbitrators, counsels, and witness sitting in different parts of the world and all joining in virtually. And also, in order to optimize time, I will not be going through each of the items in this checklist. I will just look at a couple of items which I find very relevant and important for discussion. But we've made these checklists in a manner that you can screenshot them and keep them for your own future reference. And you can see a couple of things are things that you probably already know. Internet and your laptop or a computer. I usually prefer to have two separate computer systems running on two separate internet connections. One which you use for your main hearing, one which you use to keep all your documents and search your documents in case you need to quickly refer to them, as well as something you rely on if your main connection conks off for a second. You also should have an extra screen, a normal monitor or any other screen or an iPad or whatever you prefer for live transcription. And live transcription has evolved substantially in the last few years. You do have the ability to pay service providers and them providing you transcription with a lag of only a couple of seconds, and you having almost in the form of subtitles everything that is being spoken appearing in front of you in a screen in an arbitration. Then other things, phone for an audio dial-in. In case your internet connection conks off and you can't access your audio video, you always need to have the ability to just dial into your hearing and follow what's going on. You can't miss what is happening in a hearing because there were some technical issues on your end. In addition, mic, audio input, earphones, headphones with backups, lights, and chargers for everything. Let's look at softwares. Right now, we have a bunch of softwares: Zoom, WebEx, Teams, BlueJeans. There are a number of softwares available. Most of them work well. Okay. There are some slight subtle advantages of one over another, but most of them work fine. Also, you should have a PDF editor like with OCR capacity so that you can control F on your documents, and your normal Microsoft tools. A few other things that you need to think about: your office protocol, or if you're doing a hearing from home, your home protocol, that asking everybody in your family to switch off their Wi-Fi and move to 4G so that there is no disruption and things like that. And also ensuring that you tell your team and your family that, like, to make sure that there are no loud noises in the background. You try your best to avoid these situations. Other things you should be thinking about is the background, the camera positioning, lights, shadows, and testing of your equipment before you actually jump into a hearing. Now, we have talked about why we should be doing virtual hearings. We also talked about how and what setup that we require to conduct virtual hearings efficiently. Let's now move on to the document which outlines how to do a virtual hearing efficiently, or the logistics protocol. The logistics protocol, as the name suggests, is a document that outlines the protocol to be followed in a hearing. It sets out the preparatory steps that you need to do before your virtual hearing, as well as other steps that you need to do to efficiently conduct the hearing. It's not a mandatory document. You don't find it in every arbitration, but it's actually a document that has recently evolved in order to make the process more efficient, as well as streamline the proceedings. A logistics protocol is usually agreed between the parties, and it's agreed without the involvement of the arbitral tribunal at first. The areas where parties do not agree usually ends up becoming things like additional protocols. So it's very common to see arbitrations where you have a common agreed logistics protocol, as well as a claimant's additional protocol on, let's say, witness examination, and a respondent's additional protocol. And then you take all of these and place them before the tribunal and tell the tribunal that, look, we agree on these issues and we disagree on these issues. And the tribunal has the final say on all issues of procedure. This is a document that has evolved recently by virtue of both party autonomy, as well as an arbitrator's procedural flexibility in conducting the arbitration process. And a logistics protocol has to be drafted very carefully. It can change the balance of a hearing much more than people end up realizing at a preliminary stage. And it can also completely impact your ability to be effective and ability to be persuasive during the course of the hearing. Now, the logistics protocol will have various topics covered in it, and there is no exhaustive list. As it is a party autonomy document, it could have anything. We have prepared, again, a list for our own internal use, which we are happy to share with you. And this list, again, like many of our working lists, keeps on evolving. You can screenshot this list for your own internal use so that it is of help. And the reason we've created these lists is because we had a tough time when we were doing this for the first time. We wish that these lists were there, and they would have certainly made life easier for us. And again, I'm not going to go through each and every point here, but just a couple of things. In addition to the logistics that your protocol will include, it will also talk about things like confidentiality and security, obligation not to record the hearing or not to let any unauthorized person sit in the hearing. It will also have the hearing schedule, which, trust me, becomes very difficult to make, especially when you have witnesses all over the world. And if you have parties joining in from different time zones. In that, one good practice is to have a day-by-day schedule and all times translated into a neutral time zone, as well as the relevant time zone of whichever, for instance, a witness is being examined. So you have both a neutral time as well as what that time translates into in the witness's location. Now, the neutral time is usually the time zone of the seat of arbitration, and usually the place where the tribunal is sitting. So you always think of what is the most convenient option for your arbitral tribunal. Sorry. Yeah. It will also talk about witness hearings and how that will happen. it will talk about administration of oaths, how examination of witness will happen. Very importantly, it will talk about how the camera placement and how many cameras will be there in the room. Again, there are various opinions on this. In an ideal situation, what I prefer is 2 cameras when you're examining a witness, one right in front of the witness so that you can see the witness on a magnified screen when you're cross-examining, as well as another camera in the room, which has a broader field vision of the whole room so that you can see that there is nobody feeding the witness answers. Also, I, in an ideal situation, prefer both of these cameras to be connected to different internet connections so that if one conks off, you still have another one. Okay. You also have directions in your logistic protocol, like nobody else should be in the room when the witness is testifying, so on and so forth. And you will have requirements for training and testing. Sometimes you will have to train your witnesses on how to use Zoom, especially when we started. Now, still a lot of people are very comfortable using systems like Zoom and Cisco, but initially, some of the witnesses actually required half an hour of training on how Zoom has to work. And all of these will be incorporated in your logistics protocol. You can have a neutral professional ODR service administering your virtual hearing. It will make it more convenient. I've had the chance to use the most sophisticated ODR service providers which are available right now in the market, including Maxwell ODR services and all of those. I've also had the chance to sit in hearings and attend hearings which are administered on Zoom by court staff, as well as hearings which are managed completely by the lawyers and the arbitrators internally. My experience so far in this has been that you can get a professional ODR service provider to administer the ODR and neutrally manage the hearing, especially if it's a bigger and a complex hearing with a lot of parties in different parts of the world and with tribunal, parties, councils, everybody, large number of people attending in different parts of the world. But in smaller arbitrations, you can do this just as efficiently by using an excellent tribunal secretary who understands both arbitration as a process as well as is adept at using technology. Now, so far we've been talking about the how and why of conducting virtual hearings. Let's talk about the softer skills. Let's get back to advocacy. And let's talk about advocacy on a screen. As I said before, advocacy is the art of persuasion. Virtual advocacy is the art of persuading somebody virtually by using screens and cameras and audio video devices. Currently, we use softwares like Zoom, WebEx, Hangouts, BlueJeans. And in the future, technologies like 5G, holograms, haptic touch, all of these may completely change the experience of advocacy. And right now, let's look at acing how we can do this best while we are doing it using these softwares. Persuading somebody using audio video while looking at a screen is a skill set which has some similarities with normal arbitration advocacy if you were doing it in a physical arbitration hearing, as well as some differences. A few years ago, I had taken a session on arbitration advocacy at a premier law school in India, Nalsar, Hyderabad. The session was uploaded by the university on YouTube, and you can find it if you do a few quick Google search. And I'm hoping that this session complements what I said there, instead of just repeating the points that I've already made. And I'm hoping to focus this more on the additional things to keep in mind while doing arbitration advocacy while looking at the screen. Now, whenever a message is being conveyed to your audience, there is a degree of persuasion involved. It may be positive or negative, subtle or overt, conscious or unconscious. And so everything you say or that your audience sees will in some way impact the message that you are transferring across, and it will impact your advocacy. It includes the background you use, the static noise of you unconsciously tapping your foot under the table, and various other things. Everything which is conveyed will convey a message and will impact your advocacy. And remember, it is easier to lose attention and drift off in a virtual setting. And that's probably just a problem of 2D versus 3D. I'm pretty sure that some of you in this live session, you aren't hanging on to every word I'm saying, and you would have drifted off onto some other thought, checked your phone some point or the other, and that is normal and natural. Arbitrators are also human, and understand that it is your job to keep the arbitrator's attention. My experience with virtual hearings has also made me feel that the importance of a written advocacy has increased, because in fact, most arbitrators are now coming better prepared after having read, and are usually inclined one way or the other even before the hearing starts. And therefore, written advocacy becomes very important. Beyond this, allow me to just provide you with a few thoughts and opinions about how to do these situations better. And you can take these thoughts and adapt them to your own situation. Give me a second as I pour myself another cup. Let's start with audio and video. It is all right to ask your audience in a virtual hearing setup if they can hear you or see you properly. This is because this is a real problem. You would rather confirm this instead of just starting off and then realizing that they did not receive or partially received the message you were trying to convey. And I personally feel that this problem will be short-lived, and it will completely vanish with the advent of 5G technology and with higher data speeds. But currently, it's a good practice to confirm. I also prefer to have somebody from our team listening into the audio feed from a different internet connection and dropping us a message in case that there is some lag or there is some suddenly the audio or video conks off. Moderating your speech and your volume, the speed at which you speak as well as the volume, becomes very important, especially if you are addressing an arbitrator or a tribunal from a different cultural background, or even a witness from a different cultural background. If you rush into your points and quickly ask your questions, being completely ignorant of the cultural and accent differences that may be there, you can both lose your attention as well as lose the gravitas of your points. It's also good practice to constantly keep checking your mute and video buttons. It's just make a habit of it. It's really good. And remember to mute when not speaking, especially when you're coughing and sneezing in a virtual arbitration, because this can suddenly distort the audio. And given the times we live in, it will subconsciously make your audience want to distance themselves from you. It's sad, but it's true. On the video format, understand that sometimes the arbitrators will see you as a thumbnail, and sometimes they will see you as a full-blown picture on their widescreen TV. Being conscious of what is there in your background and tailor-making it to suit your preferences will provide you with some subtle benefits. Another thing, have a proper name at the bottom. Like, for instance, Respondent Counsel Garv Malhotra. Okay? It will make life easier for everybody. Use softwares to your advantage. For instance, when you are sharing documents, the ability to split screen and share it is very good. For instance, when you are comparing signatures on two documents, it's brilliant the ability we have to put them on a split screen side by side and show it to the tribunal by just sharing the screen. And that is very impactful. So learn how to use these technologies to your advantage. Another thing, sniggering and smug faces and like making sly comments sometimes end up being much more magnified in a virtual hearing. We don't end up realizing it till we see somebody else do it. It would be good to keep this in mind. And it's also because in a virtual hearing, there are often situations where you can see multiple people's faces at the same time, instead of just the usual focusing on one person at a time. Now let's talk about camera. Looking into the camera is very important. I know this is hard, and I know we're not used to it. It takes some time, but it is important to be conscious of the fact that you need to look into the camera. To everybody has their own ways. My personal hack is that I prefer to I just print a thumbnail version of the tribunal's faces and actually stick it behind. Or if I'm doing a webinar, I take a post-it, draw a smiley and stick it right behind my camera. To each their own. I find this hack as very useful, and I always find that this helps me just look at the camera a little more. So find your own way, whatever works for you, but camera positioning as well as looking into the camera is important. Also, while addressing the tribunal, ideally, I prefer to have the camera slightly higher than eye level. And that's just because of the feeling of the tribunal looking down at you, or the judge looking down at you. It's a psychological thing, but they are used to this, and it's just more comfortable for everybody. In some ways, in a virtual hearing, we are emulating what we know a physical hearing to be. On the other hand, when we are examining witnesses or speaking at a webinar, I prefer to have the camera at eye level, just so that it feels more conversational. Talking about screen share, get comfortable with sharing your screen and keep a folder of documents that you will quickly want to share with your tribunal. You should not be frantically looking for that right document at the right time. If you can do this right, it is very, very impactful. Visual aids like PowerPoint presentations, these all can be used. But my suggestion is that you use them to emphasize your points and signpost your arguments to show where you're going, instead of having your PowerPoint make the argument for you. Another thing that I think will possibly improve your efficiency as well as the advocacy experience altogether is getting comfortable with multiple screens. it really works wonders if you can have multiple screens whereby you can look at the tribunal, your notes, the hearing, transcription, and talk to your team all in tandem. This can really help out. Now, keeping an eye on the clock, I think I should now quickly jump to the last topic for our session today, which is witness examination. Now, the legendary late lawyer, Mr. Ram Jethmalani, had once told me many years ago when I was an intern, that the art of cross-examination is dying. I believe that cross-examination of witnesses on the screen may possibly lead to a rebirth or a metamorphosis of this practice into a completely new art form. There are new things that we are learning about advocacy and especially cross-examining. There are advantages and there are disadvantages. Examination of witnesses virtually is an evolving topic, and most of us lawyers still swear by the advantages of a physical examination. But at the same time, there are situations where a virtual cross-examination is equally effective, if not more. And this is especially because, at least in arbitration and commercial disputes, examination of witness looks nothing like you see in the movies. It's a very calm, composed process which has a question and an answer, and there are very few high-pumped, adrenaline-heated moments. There are, but there are few and far between. And of many witnesses can just be examined on more mundane points. If we talk about examination of witnesses, honestly, I've done it. I've seen it done a few times, but all of this has been lesser than the number of times I would have liked before I was teaching this subject. But also, like, I still prefer examining key witnesses in person because of the ability to note body language, demeanor, and various other factors. But still, like many professional resources in the pandemic era, I think guidance based on limited experience on this topic is still better than no guidance. And when we were doing this, we had barely any guidance on how to do this well. And with this, let me share a few points with you, which I've collected over the last year, as well as what I taught to my class at NLS Bangalore last month. First, let's understand that while doing the exercise of witness examination on a screen, the witness usually appears bigger and closer than how it happens when you're doing the examination in a physical hearing. In a physical hearing, usually the witness is standing or sitting on the other side, and you are from a distance examining them. Whereas in a virtual hearing, you do have the witness right in front of you, and you can probably like bring the camera closer, further when you start off according to your preferences. And that has its own advantages, because in one hearing, we could see sweat trickle down slowly down a witness's face. And these things are very, very impactful. Now, when you're doing a witness examination virtually, at the start, it's important to ensure that the oath is administered to the witness. Sometimes people forget this in virtual settings, and this comes back to haunt them when you have to remind the witness that he or she is under oath at the particular time, and you suddenly realize that you have forgotten to administer oath. So it's very important to keep this in mind. Second, it's important to be extremely organized with your documents in soft copy, especially the ones which you need the witness to refer. Very often you want to draw the witness's attention to a particular document and say whether this is your signature, or what was the thought process at this time, or whatever, for various reasons, depending you're examining, chief examining or cross-examining, you will want to point your witness's attention to a particular part of a document. And that's done much more efficiently in a virtual hearing. And you realize how efficient this is once you do it, because trust me, very often in an arbitration, you have situations when you're telling a witness, please go to bundle C3, page 246, para 4, last line. And then you're waiting for like another 3 minutes while the witness pulls out bundle C3, locates the right page, goes to the para there and confirms that, is this the line you're asking me about? Takes some time. Instead, it's so much quicker if you say that, please refer to bundle C3, para 246, page 246, para 3, last line, and then boom, in a second, it's there in front of the witness. Both this process is efficient. It cuts down the time, as well as sometimes it gives you the opportunity to confront the witness and have some very valuable inferences drawn based on their expressions and demeanor, being suddenly confronted with the relevant parts of such documents. Also, it cuts down the time that the witness gets to think about your question and prepare the answer for the question. Another thing you should do is keep an eye on the tribunal, either yourself or with the help of your colleagues, while doing virtual cross-examination. Because at the end of the day, it's not your job to convince the witness. You have to convince the tribunal. And sometimes, I know some of you may not believe this, but people actually forget this. And sometimes you have situations where counsels start fighting with the witness, trying to convince the witness that they are wrong. So keep an eye out on the tribunal, see how perceptive they are being to a particular line of examination. Now, what do you do if your witness keeps freezing? Especially, what if the witness keeps freezing every time you ask him or her a tricky question? Now, and what do you do if you're apprehending that somebody's feeding your witness answers? Because honestly, there are ways to reduce the risk. I don't think, at least right now, given how technology is, there are ways of doing this foolproof. At least right now, with my limited experience on the technologies that exist today, based on systems which weren't necessarily created for conducting cross-examination and witness examinations efficiently, right now, you have ways to protect against witness coaching during the hearing. And one way to do that, as we discussed, was having 2 cameras, okay, based on 2 different internet systems, because it's highly unlikely that both internet connections will freeze at the same time. So even if your main connection is freezing, you can see that the witness is trying to resolve the situation, and not just freezing the system while he or she confers with somebody else. If the problem happens with suspicious frequency and you need to take a judgment call at that time, it would be good to draw the tribunal's attention to that happening, and sometimes read this into the transcript. That means your live transcript, you can read this into the transcript, so that when you're making your closing submissions, you can take that out and quote it from your own transcripts. And you can request the tribunal to draw adverse inferences based on this. Now, with an eye on the clock, we are almost at 7. So I'm going to wind up. Before I go, I'm happy to take questions. I already see that there are a bunch of questions. While I was speaking, the chat box kept lighting up. I'm happy to address your questions. But before I do that, I just have one final thought. These are difficult times. But tough times never last, only tough people do. And the pandemic will one day be over. But people will remember. People will remember things. So be very genuine and understanding to people at this stage. Be genuine to arbitrators, opposite counsels, clients, witnesses. Cut people slack because you don't know what they are dealing with right now. Also, find it in your heart to donate generously to whatever cause you believe. If you can trade some of your money and some of your time to save a few lives, just the good karma itself will bring you a lot of luck and happiness. Thank you for listening to me. Thank you for your time and stay safe. I'm happy to take questions.
So there are a couple of questions in the chat box. Can you see them or I'll leave it to you?
How about you pose the questions one by one to me? Is that
Yes.
all right?
Yes. The first question from the attendees is that what are the most challenging aspects of moving to virtual hearing?
And everybody has their own challenges. I am personally a tech enthusiast, so on the technology side, I really did not have much troubles. But for me, the biggest challenge was the mindset. And again, it's too early to draw patterns right now and say whether the perceived the bias or the absence of adequacy of a 2D system to give you an opportunity of a full hearing, whether that was a perceived issue or was that an actual issue. We still need much more experience doing this before we can really confidently make patterns and give answers on that. But for me personally, the biggest challenge was the change in mindset, my own mindset.
Yes, sir. So the next question is whether an online
Sorry. I'm not sure if you can hear me. I certainly cannot hear you.
Am I audible?
Now you are. Please go ahead.
So the next question is whether an online setup is caused an hindrance with respect to the aspect of privacy in an arbitration proceeding.
So far, it has not been my experience that we are seeing some privacy issues. There are red flags. There are certainly problems that come along with conducting a hearing online. Obviously, the most secure way of communicating is walking up to somebody and whispering something in their ear. And anything further from that runs the risk of your conversations being bugged and one way or the other having some privacy concerns. But I do believe that technology has evolved such that we are able to safeguard against those exposures, from simple steps like password protection of meetings to steps like admitting on a specific person only basis to encrypted hearings, which is now not such as complicated as the idea would have been a couple of years ago. So in summary, no, I don't think that we are facing a lot of privacy issues. But as I said, most of the answers I give right now are based on very limited experiences that we've had in a very short period of time during the pandemic. If you ask me the same questions a couple of years down the line, perhaps my experiences would be different and my opinions would have changed.
Yes. So next, the attendee wants to know your opinion on the impact of virtual hearings for an experienced advocate in comparison to a new advocate that has recently graduated and is an advocate on the.
So I think younger counsel have it easier to get more acquainted with virtual hearing setups. But beyond that, there is no match for experience, because just the audio video setup is a small fraction of the whole process. The experience of experienced counsel is unmatched. And at the end of the day, beyond how the hearing looks, it's very important what you say and how you argue your case. That is the most crucial part. So I think it brings its own advantages and disadvantages to both. It's a lot of more experienced counsel, including senior counsel who are in their 60s, 70s, 80s, 90s, have also adapted to the new technological advancements with surprising ease. And therefore, I don't think that there is a substantial difference which just virtual hearings will make in your ability to be effective as a counsel.
Yes, sir. So then can we proceed to the next question? The next question is what, sir, the attendee wants to know your views on hybrid hearings in arbitration. Depending on the extensiveness of the hearing, would you encourage the arbitration tribunal to be more open to it, and should it be completely virtual, or should it be completely virtual?
So I am not very fond of hybrid hearings. I think hybrid hearings are very often not fully balanced, and depending on where the tribunal is seated, there could be situations where the party appearing through video may be disadvantaged because they are appearing through video. Ideally, I prefer a wholly physical or a wholly virtual hearing.
Yes, sir. Thank you so much for your answers. So there's another question that has come up. He said that sir, you pointed out the problem of a witness freezing when posed with a difficult question. So how do you address that? Is there any provision or ethic in place when faced with such a situation?
So again, the law on the point is evolving. To the best of my knowledge, there is no clear guideline which is binding on anybody on how to deal with such a situation. You have various documents which have come up. For instance, you have the CIR guideline for witness conferencing in international arbitration, and you have various other documents which talk about such situations, but no, specifically dealing with the issue of witness freezing when posed with a difficult question. That's more of a soft issue which would have to be highlighted before the tribunal when you're doing the advocacy exercise, and it's unlikely to capture that in proper rules and guidelines on these points.
Sir, next I have a question of my own. I would like to ask that, sir, related to the topic of privacy, do all the, the virtual hearings that happen in district courts or the state level?
Sorry, Subhashmita, I will have to ask you to repeat and slow down. Your audio is breaking. I'm having trouble following.
Sir, am I audible now?
Hello?
Sir, am I audible now?
Yes. Maybe if you switched off your video, it'll be better. Yes, please go ahead.
Yes. Sir, I just wanted to ask that do you receive any kind of certain guidelines to ensure that the privacy is maintained? I mean, dealing with the clients, the materials which should not be disclosed outside of the client attorney privilege, or does it differ in India? I mean, the proceedings in India and international arbitration? That is fine.
So again, these are new concerns that we are all dealing with. It's very important for counsels to keep their clients' data protected, because counsels should not and cannot be the weak link in the chain of their clients' data. Having said this, in virtual hearings, usually the logistics protocols end up having guidelines on maintaining the privacy and confidentiality of documents. For instance, storage on a protected encrypted cloud storage for everybody to access, and various other things. Also, internally, most arbitration practices globally, as well as the leading practices in India, implement their own internal protocols whereby they have encryption and verification systems to keep their clients' data safe. But as of now, to the best of my knowledge, there aren't any clear guidelines on how to keep the privacy and security concerns of data in check in specific context of virtual hearings.
Okay, sir. I don't think there's any other question that is in the chat box.
That's
Thank you so
excellent.
much, sir, for joining us today.
Thank you so much. Take care.